Freedom of expression is established in the First Amendment, has several different interpretations. The Supreme Court themselves have interpreted and reinterpreted what freedom of expression actually means. Does, cited from the text, no law in the First Amendment really mean no law? The courts have frequently wrestled with the question of whether freedom of expression is an absolute. The courts have often ruled that there are instances when speech needs to be controlled, especially when the First Amendment conflicts with other rights. The courts have also had to decide what kinds of activities constitute speech or press within the meaning of the First Amendment. For example, certain forms of nonverbal communication, like picketing, are considered symbolic speech and are protected under the First Amendment. Other forms of expression are considered to be action and are not protected. Now let's look at prior restraint. What is prior restraint? Prior restraint means a government preventing material from being published. Let's look at the Supreme Court case Neer v. Minnesota in 1931. J. Neer published a scandal sheet in Minneapolis in which he attacked local officials, charging that they were implicated with gangsters. Minnesota officials obtained an injunction to prevent Neer from publishing his newspaper under the state law that allowed such action against periodicals. The law provided that any person, and I quote, engaged in the business, end quote, of regularly publishing or circulating an obscene, lewd, and lascivious or malicious, scandalous, and defamatory newspaper or periodical was guilty of a nuisance and could be stopped from further committing or maintaining that nuisance. The constitutional question in Neer v. Minnesota is, does the Minnesota gag law violate the free press provision in the First Amendment? And the Supreme Court wrote in their opinion that the statute authorizing the injunction was unconstitutional as it was applied in that issue or that situation. History has shown that the protection against previous restraints was at the heart of the First Amendment, and the court held that the statutory scheme constituted a prior restraint and hence was invalid under the First Amendment. The court established as a constitutional principle the doctrine that, with some narrow exceptions, the government could not censor or otherwise prohibit a publication in advance, even though the communication might be punishable after the publication in a criminal or other proceeding. Now, under freedom of expression, let's look at Schenck versus the United States in 1919. The facts of the case are during World War I, Schenck mailed circulars to draftees. They suggested that the draft was a monstrous wrong motivated by the capitalist system, and the circulars urged them do not submit to intimidation, but advised only peaceful action, such as petitioning to repeal the Conscription Act or the Draft Act. Schenck was charged with conspiracy to violate the Espionage Act by attempting to cause insubordination in the military and to obstruct recruitment. The constitutional question was, are Schenck's actions, words, and expression protected by the free speech clause of the First Amendment? The Supreme Court found unanimously that Schenck is not protected in this situation. The character of every act depends on the circumstances. The question in every case is whether the words used are used in such circumstances and are of such nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. During wartime, utterances tolerable in peacetime can be punished. As we've said before, there are several items under freedom of expression. When discussing the term obscenity, how do you define obscene? How does your neighbor define obscene? Are they similar definitions? Ultimately, your opinion is not what's being taken into account when the law is applied. What the Supreme Court defines as obscene is the ultimate ruling and what should be followed in society, what is expected to be followed. There are two court cases that deal with obscenity. First, Roth versus the United States in 1957 ruled that obscenity is not constitutionally protected. However, the court came back in 1973 in the court case Miller versus California that community standards should be used to determine obscenity in terms of appealing to a prurient interest and being patently offensive and lacking in value. In Miller versus California, the court redefined its definition of what obscenity is. Originally, obscenity was defined as utterly without socially redeeming value. Miller versus California, the Supreme Court redefined obscenity to mean that lacks serious literary, artistic, political, or scientific value. Still looking at the freedom of expression, libel and slander are limitations to our First Amendment rights. Libel is the publication of statements known to be false that tend to damage a person's reputation, and slander is the spoken defamation. These are not protected under the First Amendment. Libel and slander involve freedom of expression issues that involve competing values. If public debate is not free, there can be no democracy. Conversely, some reputations will be unfairly damaged in the process. And the court has held that statements about public figures are libelous only if made with malice and reckless disregard for the truth. For example, this brings into light the New York Times versus Sullivan Supreme Court case of 1964. The right to criticize the government, which the Supreme Court termed the central meaning of the First Amendment, is not libel or slander. Criticism, then, is defined as something different than libel or slander. Private persons only need to show that statements about them were defamatory falsehoods and that the author was negligent. Symbolic speech as well is classified under freedom of expression in the First Amendment. Symbolic speech refers to the actions that do not consist of speaking or writing, but rather express an opinion. Broadly interpreted, freedom of speech is a guarantee of freedom of expression. Now, the doctrine of symbolic speech is not precise. For example, burning a flag is protected speech, but burning a draft card is not. If you look at the Supreme Court case, Texas versus Johnson in 1989, the Supreme Court ruled in a 5-4 decision that Johnson's burning of a flag was protected expression under the First Amendment. The court found that Johnson's actions fell into the category of expressive conduct and had a distinctly political nature. The court also ruled that the fact that an audience takes offense to certain ideas or expression, the court found, does not justify prohibitions of speech. So just because you don't like what you hear doesn't mean that it's obscene and does not mean that you can limit somebody's freedom of speech. When it comes to free press and fair trials, the Bill of Rights is a source of potential conflicts between different types of freedoms. The Constitution clearly meant to guarantee the right to a fair trial as well as the right to a free press. But a trial may not be fair if pretrial press coverage makes it impossible to select an impartial jury. How many times have you heard about a court case that's been shown all over the media and the news networks, and then when it comes time to choose a jury, most of the potential jurors have already heard about the case and formed their own opinions. Journalists seek full freedom to cover all trials, and they argue that the public has a right to know. Although reporters want trials to be open to them, they sometimes defend their right to keep some of their own files secret in order to protect a confidential source. A few states have passed shield laws, which is an important term to know, to protect reporters in situations where they need to protect a confidential source. But in most states, reporters have no more rights than other citizens once a case has come to trial. And the Supreme Court has ruled that the right to a fair trial preempts the reporter's right to protect sources, such as in Brandsburg versus Hayes, and has sustained the right of police to obtain a search warrant to search the files of a student newspaper, such as in Zurcher versus Stanford Daily. Now, free speech has its denominations. You have commercial speech, which is more restricted than are expressions of opinion on religious, political, or other matters. Well, what is commercial speech? Commercial speech is any communication in the form of advertising. The Federal Trade Commission decides what kind of materials may be advertised on radio and television and regulates the content of advertising. Although commercial speech is regulated more rigidly than other types of speech, the courts have been broadening its protection under the Constitution. And in recent years, the courts have struck down many restrictions, including restraints against advertising for professional services and for certain products such as condoms, as violations of freedom of speech. Regulation of the public airwaves is a responsibility of the Federal Communications Commission. Radio and television stations are subject to more restrictions than the print media, which is justified by the fact that only a limited number of broadcast frequencies are available to begin with. The FCC regulates the content and nature and the very existence of radio and television broadcasting. A licensed station must comply with regulations that include provisions for a certain percentage of broadcast time for public service, news, children's programming, political candidates, or views other than those its owners support. In 2000, in the U.S. versus Playboy Entertainment Group, the Supreme Court agreed that although the government had a legitimate right to regulate sexually oriented programming, any such regulation must be narrowly tailored to promote a compelling government interest. Last two rights, the last two civil liberties that we're going to discuss, are the right to assemble, the right to associate, and the right to bear arms. Freedom of assembly provides the constitutional basis for forming interest groups and political parties, for picketing and protesting in groups. There are two facets of the freedom of assembly. In the right to assemble, the right to gather together in order to make a statement is the definition. Within reasonable limits, freedom of assembly includes the rights to parade, picket, and protest. And the Supreme Court has generally upheld the right of any group, no matter how controversial or offensive, to peaceably assemble on public property. One court case to specifically look at would be the Skokie case. The balance between freedom and order is tested when protest verges on harassment, is illustrated by the dispute over protesters that are lined up outside of abortion clinics. The second facet of the freedom of assembly is the right to associate, or the freedom to associate with people who share a common interest. The right to associate includes the right to meet people who want to create political change. In 1958, the court found Alabama's attempt to require the NAACP to turn over its membership list to be an unconstitutional restriction of the freedom of association, as noted in the NAACP versus Alabama in 1958. The last civil liberty that we're going to look at today is the right to bear arms. Many communities have passed restrictions on owning and carrying handguns. This is an incredibly hot topic, especially in today's society, over the last several years and the school shootings that we have seen. Laws have mandated background checks for gun buyers and limited the sale of certain types of weapons altogether. Laws have also required that guns be stored in a fashion to prevent their theft or children from accessing and firing them.